This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. All right, so Judge William Alsup of the Northern District of California has ruled against DJ Shorty Hot Forever, Erik Mishiyev. This is the case where Mr. Mishiyev sued YouTube and Alphabet and Google over the sudden termination of their YouTube account. And you'll see, we'll get into exactly what the reasoning was. Judge Alsup does a good description in this dismissal. In this action arising out of defendants' allegedly wrongful removal of plaintiffs' videos from defendants' video sharing website, defendants moved to dismiss. Because the parties' agreement expressly authorized the allegedly wrongful conduct, as well as for other reasons stated below, the motion is granted. Motion to dismiss is granted. Defendant YouTube operates a popular video sharing website of the same name through which users could post and view video content. YouTube allowed users to upload or view videos for free in exchange for a non-exclusive license to host users' videos. Certain users could make money from their videos through YouTube's AdSense program. YouTube would display advertising in connection with a video and share advertising revenue with the user who uploaded it. As viewers, users could subscribe to another user's channel to keep up to date with new videos. Starting in 2007, plaintiff Erik Mishiyev operated two such channels, uploading videos of original music, DJ mixes, and celebrity interviews. Users viewed plaintiff's videos over 110 million times, and over 250,000 users subscribed to his two channels. Through participation in the AdSense program, plaintiff purportedly earned over $300,000 between 2012 and 2018, his primary source of income. In 2019, however, YouTube terminated plaintiff's account and removed all of his videos. YouTube explained that it terminated plaintiff's account due to repeated copyright violations. The complaint, however, alleges that YouTube did not simply remove plaintiff's content because of copyright claims, but instead in retaliation for placing YouTube on notice that plaintiff was filing a lawsuit against them. Notably missing from the complaint are any allegations that plaintiff's videos did not infringe others' copyrights. This action is about YouTube's decision to terminate plaintiff's account and disable the channels associated with it. YouTube's terms of service agreement governed the terminated relationship. The agreement vested YouTube with significant control over the operation of its service, including the ability to remove uploaded content. Section 6G of the agreement, in part, disallowed infringing material and gave YouTube the power to remove content that infringed upon another's intellectual property rights. YouTube does not permit copyright infringing activities and infringement of intellectual property rights on the service, and YouTube will remove all content if properly notified that such content infringes on another's intellectual property rights. YouTube reserves the right to remove content without prior notice. And then Section 7 of the agreement provides the account termination policy. YouTube will terminate a user's access to the service if, under appropriate circumstances, the user is determined to be a repeat infringer. YouTube reserves the right to decide whether content violates these terms of service for reasons other than copyright infringement, such as, but not limited to, adult entertainment, obscenity, or excessive length. YouTube may, at any time, without prior notice, and in its sole discretion, remove such content and terminate a user's account for submitting such material in violation of these terms of service. Section 8 provided a procedure for copyright owners to notify YouTube if the owner believed a user's video infringed upon the owner's copyrights. If the copyright owner dutifully complied with the notification requirements, YouTube would remove the allegedly infringing content pursuant to Section 6G. Section 8, listen up, this is going to answer some questions that we've had about counter notifications. If you remember, we've noticed that YouTube doesn't always obey a DMCA counter notice, despite that being the law in 17 U.S.C. 512. Section 8 also allowed users to rebut the notice by submitting a counter notice, quote, If a counter notice is received by the copyright agent, YouTube may send a copy of the counter notice to the original complaining party, informing that person that it may replace the removed content or cease disabling it in 10 business days. Unless the copyright owner files an action seeking a court order against the content provider, member, or user, the removed content may be replaced or access to it restored in 10 to 14 business days or more after receipt of the counter notice at YouTube's sole discretion. So that means that we have all been inadvertently or unknowingly agreeing to have YouTube not obey DMCA counter notices if it so decides. Beginning in March 2016, plaintiff began receiving copyright claims on his most profitable videos. If plaintiff failed to respond, these claims would leave strikes on plaintiff's channels, tally 3 strikes, and YouTube would terminate plaintiff's channel. For the time being, plaintiff succeeded in rebutting the claims and restoring his videos. By 2017, over 100,000 people allegedly subscribed to plaintiff's channels. With access to plaintiff's channels and videos restored, the number continued to increase. Nevertheless, the views on each video plaintiff posted remained low when compared to similar channels with fewer subscribers. At this point, plaintiff became suspicious of YouTube for failing to distribute his videos to his subscribers. It's a common complaint on YouTube. It's happened to our channel too. To confirm whether YouTube distributed his videos, plaintiff demanded that YouTube customer service provide plaintiff with a list of subscribers that clicked on or watched his videos. The support team explained they could not provide such information. And we've experienced this too. YouTube support gives you like the minimum answer possible, sometimes even just sending you a link. Like when they implemented the community guidelines policy, and then when they said things had violated it, many of us would write to customer support and be like, hey, why did this video violate the policy? Like, it's obvious the video didn't violate the policy. Why did you say it did? Like, what rule did we break? Point me to the rule. And they would just send you a link. They wouldn't even send you an explanation. They would just send you a link. No attempt at an explanation. In fact, I think I heard that YouTube is now considering offering to charge you money if you want to know why your video was actually taken down. Like, you have to pay for the time of the person who has to do the analysis and then send you the explanation. Eventually, according to the complaint, plaintiff lost faith in YouTube's customer service representatives. Yeah, that's completely understandable. And threatened litigation several times. The complaint points to an appended exhibit containing one such conversation, apparently to support the allegation that plaintiff threatened litigation. During the conversation, plaintiff berated a support representative and explained that plaintiff would expose YouTube's corruption. Plaintiff made no mention of a lawsuit. The complaint alleges that on December 14, 2018, YouTube sent plaintiff a notice that YouTube would be terminating his account and removing his videos due to plaintiff's litigation threat. In connection with this allegation, the complaint appended a May 2019 email from YouTube rather than the December email. According to the May 2019 email, plaintiff decided to append the December 14th email outlined the actions YouTube was taking to address plaintiff's threats made to YouTube employees. Those actions included termination of plaintiff's YouTube content licensing agreement and all channel monetization, and revoking plaintiff's access to creator support channels and YouTube Spaces indefinitely. In the month following the December 14th, 2018 notice, the complaint alleges that plaintiff became bombarded with copyright claims like he had never had before. In January of 2019, YouTube allegedly acted upon the copyright claims and blocked all public access to plaintiff's videos. Over the next month, plaintiff submitted several counter notices. In an April email appended to the complaint, YouTube explained that certain videos remained ineligible for counter notice because YouTube had already reviewed and rejected previous counter notices associated with these videos. According to the complaint, when plaintiff inquired further, YouTube retracted its statement that the videos had been ineligible for counter notice and agreed to process the pending counter notices. In support, the complaint appends a screenshot of an email YouTube allegedly sent. This order pauses to note that although the complaint suggests YouTube retracted its statements as to the January 2019 counternotices, the email appears to predate those counternotices. The email is dated September 24th, but no year is included. We can rule out September 2019, however, because plaintiff filed the original complaint with these allegations and exhibits in August of 2019. Thus, YouTube sent the email no later than September 2018, months prior to submitting the January 2019 counternotices. In any event, the May 2019 email explained that YouTube disabled plaintiff's channel because the channel received more than 3 copyright strikes, and that the information plaintiff provided in response to the copyright claims failed to show that plaintiff had the necessary rights to post the content on YouTube. As such, the copyright strikes were not eligible to be resolved. Based on that determination, YouTube explained that any new counternotices plaintiffs submitted would be rejected automatically. As discussed, the complaint alleges that YouTube actually removed the videos in retaliation for placing YouTube on notice that plaintiff was filing a lawsuit against YouTube. As a result of YouTube's decision to terminate his account, plaintiff lost new subscribers, views, future hits, performance bookings, and lost advertising and sponsorship revenue. Plaintiff filed this action in August 2019 in our San Jose division. Plaintiff alleged 6 claims, including breach of contract, intentional interference with prospective business advantage or relations, interference with contractual relations, negligent interference with prospective economic relations, and injunctive relief. In October 2019, before an order reassigned the action to Judge Alsup, Judge Davila allowed plaintiff's counsel to withdraw without substitution of new counsel. The action stalled while plaintiff sought new counsel. In December 2019, plaintiff's current counsel substituted in. Defendants now move to dismiss under Rule 12b-6. This order follows full briefing and a hearing. To survive a motion to dismiss under 12b-6, a complaint must contain sufficient factual matter accepted as true to state a claim for relief that is plausible on its face. A claim is facially plausible where there is sufficient factual allegation to draw a reasonable inference that defendants are liable for the misconduct alleged. While a court must take all the factual allegations in a complaint as true, it is not bound to accept as true a legal conclusion that has been couched as a factual allegation. Factual allegations must be enough to raise a right to relief above a speculative level. This is an oft-repeated paragraph. You'll always see this in a 12b-6 motion. Is Bell Atlantic v. Twombly and Ashcroft v. Iqbal being cited for the standard of how you evaluate a motion to dismiss? So basically, the moving party is at a disadvantage. So the moving party who's asking for the dismissal is at a disadvantage in a motion to dismiss. The court will accept all reasonably pled allegations on the non-moving party's part, the plaintiff in this case. They'll accept them as true and then see if, even with accepting those things as true, does the complaint still fail? And that's what Judge Alsup is saying here, that even when we accept all the allegations, all the factual allegations in the complaint as true, Erik Mishiyev's case still fails. And the judge goes on to look at breach of contract. The complaint alleges that YouTube breached the parties' agreement by declining to restore plaintiff's videos after YouTube removed them based on allegations of copyright infringement. The agreement, however, authorized YouTube to do exactly that. The defendants were given the right to do what they did by the express provisions of the contract, and therefore there can be no breach. YouTube did not permit infringing activities and infringement of intellectual property rights on the service, and YouTube would remove all content if properly notified that such content infringes on another's intellectual property rights. Section 8 provided an opportunity for users to rebut such a notice if they believed the videos did not infringe the allegedly protected material. Importantly, however, once a user submitted a counternotice, the agreement reserved to YouTube sole discretion to make the decision to take any further action, including whether to restore the videos or even send the counternotice to the purported copyright owner. Thus, YouTube did not agree to act as a neutral processor of notices and counternotices. YouTube retained control to evaluate counternotices and infringement on its own. The complaint omits any discussion of whether plaintiff maintained the necessary rights to the materials in his videos. Instead, the complaint claims that YouTube had a separate wrongful purpose for removing the videos: retaliation. against plaintiff's litigation threats. Even taking the retaliation allegations as true, however, the complaint fails to overcome YouTube's express right to terminate plaintiff's account for repeat copyright infringement. In his opposition brief, plaintiff relies on Storic and Storic v. Citicorp Real Estate for the proposition that the discretion the agreement reserved to YouTube remained limited by the duty of good faith. Storic, however, held that the covenant of good faith and fair dealing could not be implied so as to prohibit the defendant from doing what it remained expressly permitted to do under the parties' agreement. In other words, the covenant of good faith and fair dealing, which we don't really have a definition for here yet, but that covenant requiring good faith and fair dealing in a contract does not prohibit a party from doing what it is expressly allowed to do under the contract's terms. The defendant there had no duty to act in good faith when making its discretionary determination. It was required only to make an objectively reasonable determination. Here, YouTube allowed plaintiff to post videos on its platform free of charge in exchange for a license to its content. Videos infringing intellectual property rights were verboten, and YouTube determined that plaintiff did not have the necessary rights to use the content in his videos. Plaintiff does not dispute that determination. According to the only decision plaintiff relies on, our inquiry is over. Because the agreement unambiguously forecloses plaintiff's contract claim, granting leave to amend would be futile. The breach of contract claim is dismissed with prejudice. The complaint also alleges that YouTube breached the agreement by failing to resolve continual technical difficulties that prevented the distribution of plaintiff's new content. That failure allegedly breached Section 6F, which provides that YouTube will process any audio or audiovisual content uploaded by you to the service in accordance with the YouTube data processing terms, except in cases where you uploaded such content for personal purposes or household activities. The data processing terms, however, include no promise to distribute plaintiff's videos in any specific matter. Even if the data processing terms were applicable, plaintiff's claims are based on YouTube's decision to remove plaintiff's videos. Plaintiff does not and cannot allege that the purported technical difficulties caused the removal of the videos without severely contradicting the remaining allegations and the many exhibits appended to the complaint. So, amendment to patch up this theory would be futile as well. On the negligence claims, the complaint fails to set forth a duty that can support plaintiff's negligence claims. So remember, duty, injury, breach, and causation are the four elements of basic negligence. The complaint alleges that YouTube owed a duty to plaintiff to exercise reasonable care to prevent causing harm to plaintiff, and that YouTube breached its duty to be engaging in the conduct described in the complaint. In California, conduct amounting to a breach of contract becomes tortious, or a wrong, only when it violates a duty independent of the contract arising from the principles of tort law. Plaintiff does not plead the existence of any duty independent of YouTube's contractual obligations. In his opposition brief, plaintiff argues that his negligence claim and negligent interference with economic relations claim are both supported by YouTube's implied duty to perform its contractual duties completely, relying for support on Holguin v. Dish Network. Holguin recognized the well-settled principle that express contractual terms give rise to implied duties, violations of which may themselves constitute breaches of contract. Although the duties are implied, they remain contractual duties, not duties independent of the contract arising from principles of tort law. The negligence claims fail. So in other words, negligence is not part of the contract. Contract law would be part of the contract, and the terms of the contract would be part of the contract, but we're not going to imply a tort into a contract, I think is what the judge is saying. Plaintiff amended his complaint once and proposes another amended complaint appended to his opposition brief. Neither amended complaint deviates substantively from the original complaint. The opposition brief also fails to explain what changes could be made to the current allegations to fix the deficiencies discussed. The negligence claims are dismissed with prejudice. Tortious interference and injunctive relief. To state a claim for intentional interference with contractual relations, plaintiff must allege a valid contract between plaintiff and a third party, defendant's knowledge of this contract, and defendant's intentional acts designed to induce breach or disruption of the contract, and an actual breach or disruption of the contractual relationship caused resulting damages Plaintiff fails to identify any contract between himself and a third party. The complaint alleges that plaintiff had many subscribers, which as a result thereof, the plaintiff was making money from said subscribers, and that YouTube interfered with plaintiff's contractual relationships with said subscribers by doing all of the acts and omissions alleged in the complaint. To the extent the complaint alleges that a contractual relationship arose between plaintiff and his subscribers based on the advertisement revenue the subscribers generated and YouTube shared with plaintiff, this is a legal conclusion we need not accept as true. I'm referring back to the motion to dismiss standard in Twombly. The money plaintiff earned from his subscribers actually came from YouTube pursuant to YouTube's agreement with plaintiff. The opposition brief fares no better. Plaintiff argues that had YouTube not removed his videos, plaintiff may have gained new subscribers, views, future hits, performance bookings, lost advertising and sponsorship revenue. To the extent these economic benefits are distinct from those provided by the parties' agreement, they amount only to speculation. Plaintiff's claim for interference with prospective economic advantage similarly fails because the tort requires in part a specific economic relationship between plaintiff and a third party. Finally, plaintiff's claim for injunctive relief is misguided. Injunctive relief is a remedy, not a cause of action. California does not recognize a standalone claim for injunctive relief. Because none of plaintiff's claims for relief survive, his claim for injunctive relief fails too. For the reasons stated above, defendant's motion to dismiss is granted. Amendment would be futile. The action is dismissed with prejudice, which means it cannot be filed again. That is the final order, end of the case, so ordered by Judge William Alsup, United States District Judge for the Northern District of California. So this is the result that we have come to expect in every case against YouTube. Their contract seems to be solid. You need to find something way more unconscionable than just we didn't like YouTube's decision to terminate our channel or whatever. One hopeful thing it does say in here is that YouTube has to use some kind of objective reasonableness when making these determinations. So if you really think that YouTube has specifically come out against you and doesn't have objective reasonableness, maybe there's something in here that you could use to try and sue. But this is the expected result. We've seen this with other, versus YouTube cases where people have had a channel demonetized, like PragerU, or otherwise have had a channel terminated and things were not explained. So either demonetization or not explaining your termination or simply not servicing your account the way you want are not causes of action. And so I feel really bad for DJ Shorty, for Erik Mishiyev, because it is a situation where you believe that you have something good going and that your money should keep coming in. And this is one of my continued fears with Lawful Masses, is that there will be some minor disagreement between me and YouTube will totally terminate our account. I don't think that's going to happen, and we are pushing forward as if it's not going to happen, but it is constantly something in the back of my mind. You've even seen me censor my words where I'm talking about the current shelter-in-place situation, and I won't say the V word or the C word because those things could get the channel completely struck or at least make the algorithm think that we're something other than legally reporting and factually reporting and accurately reporting what we can in educational mission. So as we get more trusted by YouTube, I'm less and less concerned about it, but I still have it in the back of my mind at all times. So let me know what you think in the comments below. Do you think that's the correct result? Is it correct legally, even though it feels bad? Or do you also think that there's some other legal argument that you could make that maybe wasn't made here, or maybe the judge got wrong? We do generally in the law respect Judge William Alsup as a judge. He seems to make good decisions. So it's even harder for me to say, oh yeah, Judge Alsup was just wrong. So yeah, let me know what you think in the comments below. So that's our show, everyone. I'm Leonard French, your favorite copyright attorney. Thank you to Brandon and Tack for joining me for this morning's show. Thank you for watching this production of Lawful Masses, your favorite legal news and education channel. Please subscribe to our YouTube channel. Please support us on patreon.com/ljfrench and sponsors.com/law. This channel would not exist without your support. We also have YouTube memberships available and Floatplane memberships available. Thank you to our $50 plus supporters in the month of April. Thank you to Wes Delj, Video Quarantined, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Michael Pearce, Jan Negrey, Daniel Perez, Aspernari, Joe Tyson, Benjamin Hitov, Steven, Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Nicely Done Defense, Mullen PC, Sean McNamara, Josh Baker, Ugly Grill, Gregory, Shielo T, Michael Moore, and Beastman. I appreciate you all. All the $5 plus supporters are scrolling on the LED panel over here. You'll all appear in the description of the videos that drop. I'm Leonard French, your favorite copyright attorney. Have a good week. Have a good, hopefully, final weeks of shelter in place and quarantine and all that. And I'll try to keep you up in the legal news and education with our channel here. I'll see you in the next one. Love you all. Bye.